Well, we know how that ended, at least at this point. I don't believe that that is over by far because obviously, as you probably know by now, Nathan Wade was effectively ordered off the case, or Fani Willis would have to remove the case from her entire office. So Nathan Wade fell on the sword. This was a split decision by the judge. And this is the perfect example of another subject. And the subject is why we should not have elected judges. I believe the United States is the only country in the world with elected judges. And the things that have been going on currently in the world and on our news cycle shows you perfectly why we should never have elected judges. The judges should be appointed, and in my perspective, appointed for life. If they are removed, or if there's a mechanism put in there to remove them, fine. Give them a siphon, a retirement, a whatever, so they're not looking to make decisions so that at some point in the future they can get a job with a law firm or someplace better. I mean, these people have to be similar to the justices on the U.S. Supreme Court. And frankly, the U.S. Court of Appeals, these folks are all appointed. And short of an act of Congress, they cannot be removed from the bench. The fact that we allow elected prosecutors, and I should say elected judges specifically, to be the way things work is an absolute outrage. Outrageous. That's the reason why you have someone like Attorney General of New York, Letitia James, saying as she's running for office, hey, elect me and I'm going to hammer Trump. I'm going to go in every single day finding a way to make his life miserable. He is going to know my name personally. One of her constituents asked her, says, are you going to go after and get Donald Trump for us? And she goes, oh, yeah, I'm going to be a real pain in the beep for him. So it's just the way it is, and it should not be this way. We should not have judges that are elected because they're going to do things like Scott McAfee just did. He knows that he's got a re-election. I believe his election is coming up this May. He knows he's up for re-election. And so because he has one or two people running against him, what does he do? Well, think about it from his perspective. He's got a wife. He's got children. He knows where his bread and butter is buttered, so to speak. He has to keep that job. He doesn't want to be out of office and out of work and out of a paycheck. He knows that the area he represents in Fulton County is a minority area that unfortunately is very supportive of the district attorney, Fani Willis, and her continued corruption and thieving and stealing and whatever else nonsense they're doing over there. So he's like, I got to find a way to balance this out. And that's exactly what he did. He got rid of Nathan Wade. And in my opinion, he wrote the actual ruling in such a way I cannot imagine that the Georgia Court of Appeals will not take this case. I know a lot of the talking heads out there, friends, are saying that under no circumstances is the Georgia Court of Appeals going to take this case. I'm telling you right now, they're going to take the case, period. The reason they're going to take the case is this is the kind of case any type of appellate court, any type of Supreme Court looks for. And that is a case, number one, of high public interest. And most importantly, number two, there's actually a discrepancy in the law, if you will. The need is there to have guidance. The need is there for clarification. The desperate need is there to clarify under Georgia law when and if a district attorney or some prosecutor can be removed off a case. Remember, the two conflicting examples were, number one, is it simply just the appearance of something wrong, like impropriety? And that has always been the standard that I have seen. And then number two, or do they have to prove an actual conflict? Now, in my opinion, I believe they proved an actual conflict. I mean, I'm sure you probably agree with me. It's really clear. It's obviously clear that there was an apparent conflict with this case between Fani Willis and Nathan Wade because they were financially benefiting from this case. They get to be known, famous, popular. Their names are everywhere around the entire world. And at the same time, they're enriching themselves. Nathan Wade has never seen money like this. That's clear from the divorce filings that I've already reviewed. He's never had this type of money. And now he's essentially had $1 million plus fall into his lap for basically nothing, in my opinion. So this is a lot of money. This is something that should be taken up by the Court of Appeals because it's just wrong. There's no way to have this type of corruption or evil, if you will, in a district attorney's office and say, basically, I'm going to go ahead and surgically cut out this cancer called Nathan Wade, yet the rest of the case is still okay. It's just an outrage that has went forward like that. Do you agree with me on that? Let me know if y'all agree or disagree, because I would like to know your comments on that. Okay. It says Atlanta, former Fulton County Special Prosecutor Nathan Wade is facing accusations of neglecting to cover urgent medical procedures for his ex-wife and helping support the couple's children, according to an application for citation of contempt filed with the Cobb County Superior Court on April 3rd. The papers we're going to look at clearly show, I believe it was 5:30-ish in the evening yesterday, that the actual contempt filing was made. It goes on to say Wade was appointed as the special prosecutor by Fulton County District Attorney Fani Willis to investigate allegations of election interference by former President Donald Trump and his supporters in the 2020 presidential election. Reportedly compensated nearly $700,000 for his work over a 2.5-year period, Wade's investigation led to the indictment of Trump and 18 others in August 2023. Nathan and Joycelyn Wade were married on June 21st, 1997, and separated on August 5th, 2021. There's a little discrepancy on that, but we'll go with it. With Nathan filing for divorce on November 2nd, 2021, one day after being hired by Fulton County. And of course, we just discussed that. Joycelyn Wade files for a motion to reopen discovery. In September 2023, Joycelyn Wade filed a motion to reopen discovery in their divorce case, citing Nathan Wade's extravagant spending habits and inadequate financial support. As a result, Nathan Wade disclosed credit card statements in December revealing non-work related expenses with Willis. You can imagine how his soon-to-be ex-wife, Joycelyn Wade, had to feel. Can you imagine hearing in the press that your husband, because they're still legally married, wrote a check for $750,000, and essentially you had sweet Fani going off to wherever with him and spending her money? I would imagine she had what could best be described as an extreme reaction to the situation. That's just my guess right here. All right, Michael Roman files a motion. In January 2024, one of Trump's co-defendants, Michael Roman, filed a motion seeking the disqualification of Willis and her team because of an inappropriate relationship with Wade. The motion also accused Willis of benefiting from hiring Wade. So they have the timeline here. We're not going to get into that. It goes on to say, initially, Willis and Wade declined to comment on the accusations and refrained from confirming or denying the alleged relationship. On January 8th, Joycelyn Wade served Willis with a notice of deposition. However, before she was scheduled to testify, the Wades reached an out-of-court settlement, relieving Willis from further legal obligations. And that was the case we watched together in Cobb County, which Cobb County, if you didn't know, is just kind of north. I'd say it's northwest of the downtown Fulton County / Atlanta area. And that's where they had to go to have this particular divorce proceeding enforced as far as the discovery goes. In other words, it's basically what they consider compelling her to testify is what that boils down to. And it goes subsequently, Fulton County Superior Court Judge Scott McAfee presided over several days of testimony concerning the original motion filed by Roman and similar motions from other defendants, including Trump. Wade and Willis asserted their innocence, stating they derived no financial benefit from their involvement in the prosecution of the Georgia election interference case or their relationship. Following these unprecedented proceedings, Judge McAfee ruled that neither Willis or Wade he ruled Willis or Wade must recuse themselves for the case to proceed. Wade resigned from his position a few hours after the ruling. And then, of course, we have the document right here, urgent medical procedures needed. She has been, and I'm talking about Joycelyn Wade, she's been talking about the fact that she has had to put off medical procedures that she needs because she's essentially destitute for quite some time. In a way, this is not really new news. The news is she's seeking essentially criminal contempt from Nathan Wade to have a judge compel him to do what he said he would do, to abide by their agreement. And apparently he is not able or willing to comply with what he is supposed to do. But her attorney has been in several interviews, one specific that I clearly remember, where this is what she was talking about, saying that Miss Joycelyn has issues, health issues, and she needs help. And instead of receiving help from her husband, remember they're still married, Nathan Wade, Fani is out spending their money, having a good time while she's in Atlanta sick and in need of medical attention. I mean, that's just crazy when you think about it. It's just wrong on so many levels. Nathan Wade allegedly instructed his ex-wife to cover the expenses himself with reimbursement at a later date, despite the court order mandating him to make direct payments to the healthcare provider. Folks, I can tell you something. If you are ever told to do something, you need to do it, period. End of discussion. I can tell you from just memory and just things I've seen, people I've known, you don't defy the people with the black robes. If you do, you're going to have a really, really bad day and probably bad months, if not bad years. Do not do that. Do not cross the court. If they tell you to do something, you need to do it. If you can't do it or there's some other problem, you need to make sure the court is aware of that. You need to make sure your attorney is aware of that and that they contact the court. If for some reason you don't have an attorney, you better be down there talking to the judge with a handwritten whatever's going on. Make sure you don't ever defy the people with the black robes. That's the takeaway. Nathan Wade tells children to get money from Joycelyn. Moreover, Nathan Wade is accused of discontinuing financial support for their children. Now, this is going to be kind of weird because I thought their children were adults, but I don't know, because my understanding is when he filed for divorce, he literally dropped the kids, quote unquote kids, off at college, and he signed this contract with Willis and then filed for divorce. But I'm not exactly sure of their ages. Maybe it will give us more information here in a minute. All right. He reportedly informed their daughter, currently in college. Okay, here we go. Currently in college, aspiring to attend medical school, that he would no longer cover her rent and living expenses. He told his daughter this on the day that her rent was due, according to the filing. Oh my goodness. Father's Day is going to be very weird in the Wade home. Similarly, Wade reneged on his commitment to finance their daughter's MCAT expenses. Their son, pursuing a professional soccer career in Europe, was also informed by Wade to seek financial support from his mother, despite the fact that Nathan Wade promised to cover his son's expenses so he could obtain a visa. Wow, that's really striking when you think about that. We're going to read the document together. Generally, you don't have to support adult children unless they have some type of handicap or there's some other issue. I know the state of Georgia is unique in that if you have a child that is special or has special needs, you can be on the hook indefinitely for the child support. Every state is somewhat different as far as that is concerned. However, even if they are adults, if he has agreed to do A, B, and C in an agreement that was approved by the court, that's where all this kicks in, and he could end up in serious trouble from this. All right, dire financial straits. Joycelyn Wade claims that Nathan's abrupt termination of support has left her in dire financial straits with a monthly income of less than $1,000 since she is now providing for their children. Additionally, Wade reportedly owes $15,000 to Joycelyn Wade's financial expert, who, with his failure to provide the owed amount, exacerbating the financial strain. On March 16th, Nathan Wade canceled an interview with NBC's Meet the Press on March 16th, citing a family emergency. The show announced the change in the schedule, highlighting Wade's last-minute cancellation. It is unknown what the family emergency may have been. The plot thickens, right, folks? Isn't that interesting? That is sad on so many different levels. But I happen to have, let me switch over. Yes, I have the actual document, and we are going to get into that. So the takeaway on this particular story we just read is Nathan Wade is in trouble. He obviously is not fulfilling the obligations that he said he would take care of. Apparently, he was ordered by the court to do exactly what the agreement said he should do, and apparently he has not done that. And if that's the case, he's got some serious problem. All right, so we're going to switch to the actual document itself. Let me take a couple of your questions here. All right, we're going to stop that screen. Okay, let's take a quick peek at what we got here. Zach, I watched the lead attorney's live chat this afternoon. He covered Wade's temporary order of divorce and asserted that Wade was extorted to protect Fani from having you. I would probably agree with that. I have not read it yet, but that's probably true. But that's too bad because that's not an illegal extortion. I would think the extortion you're referring to there would be a word meaning pressured. He's in a place we would generally call that what, folks? Between a rock and a hard place. Yeah, you have the world's eyes looking at Nathan Wade, Fani Willis, and Nathan does not need this problem in the background where he's got a soon-to-be ex-wife roasting him on TV. I can imagine he was in a tight spot and would probably sign anything and everything he had to sign to get out of it. So it is what it is. We'll just have to see how this works out. And let's see, Lynette, thanks for joining us again. I appreciate it. Good evening from Kentucky, from Michigan, or good evening in Kentucky from Michigan, vacationing. Well, good. Have a good vacation. Good to have you. Zach, Wade agreed to pay $70,000 a year alimony, $45,000 attorney fees, $15,000 in accounting fees, uncovered medical bills. Wow. Yeah, and she doesn't have a job, and they were married a long time, and this is where this type of problem really can be very nasty and sad. The agreement was to pay the medical bills. Yeah, we're going to dive into that right now. See, this is the reason why when you have a long-term marriage like this, folks, this is where it gets really sad, and it's unfortunate. I don't know exactly what the circumstances were for this particular divorce, but obviously there's some serious issues here and some serious problems going on. And I feel bad, frankly, for Joycelyn Wade because she has given 20 some years, 26 years to this man. They've raised their children together. I see a lot of stories, and I don't know if this exactly fits this story, but I see a ton of stories where you have basically the breadwinner, generally maybe the husband, he's going to law school. She's working with him to go to law school, puts him through law school. At the same time, they have a family together. They have their children together. They raise their children. She's working at home as basically what we would refer to as a housewife, as I guess they call it domestic engineer. Nothing wrong with that. That's great. But they're working as a team together. Unfortunately, now that they're going to get a divorce, he's the one that makes all the money. She doesn't have any marketable skills right now, definitely no skills on the level that he has. And if that is the case, as I described it, she is definitely entitled to something substantial in the form of alimony. I am pretty confident that the state of Georgia has alimony provisions. And if there's any case that would warrant alimony, it would be this type of case. Generally, like I know here in Florida, you got to be married 7 years, 8 years. Nowadays, the courts really don't like alimony. I mean, I'm just telling you, they don't, because they know people are divorcing all the time, and they don't want a situation where, let's just say it's a woman. A woman's living with a new boyfriend, but they won't marry because she's getting all that money coming in. I mean, it gets really touchy and it gets complicated. But this type of situation, in my opinion, is a no-brainer. 20 some years of marriage, she's apparently raised the children. He's now a practicing lawyer, able to make the big dollars. She's entitled to be taken care of. I don't really care what the situation is. That's just the way I see it. Y'all agree, disagree? Put in the comments below and I'll be happy to take a look at it. All right, let's go ahead and let's look at this document right here. I think I'll just do it this way. All right, let's take a look at this and see how this works out. Okay, this is the actual document. I think it's 20 some pages long. And yes, 22 pages long. Let's take a peek at it. Obviously, it's in the Superior Court of Cobb County, state of Georgia. You have Nathan Wade. He's the one that actually filed for divorce some time ago. It's been years ago. It just has not been brought to a conclusion. And then Joycelyn Wade, of course, the soon-to-be ex-wife, that is the defendant. This is a certificate of service. The certificate of service, we're going to start back up here at the top, though. That's what happens when I preview. All right, same thing I just said. Remember I mentioned earlier that it was filed yesterday? It was April 3rd at 5:15 p.m. When you file paperwork with the court, a lot of times now you can do it electronically. Most attorneys, even today, when they have something they want to file and they want to get it done as soon as possible, they generally bring the paperwork over to the county recorder's office in Cobb County, Georgia. You can show up at the Superior Court. You generally bring 1 or 2 copies. You give the court an original, and then you have a file stamp copy for your records, and they literally have a machine that just click like that, and it will stamp it just like that. So I'm not sure if this was done electronically, or actually it does say what it's e-filed. So you can either e-file it or you can have it stamped just like I described. Admittedly, the stamping is a little old school, but it is something that is still done if people want to get it done right away and have a file stamp copy for their record and or for their client. Defendant's application for citation of contempt. When you see contempt, if you're the person receiving the contempt motion, that is not a good place to be. Comes now the defendant, Joycelyn Wade, and files this, her verified application. Does anybody know what verified means? It simply means it is notarized. Certain types of motions, certain types of pleadings have to be verified, aka notarized, because when you sign these type of documents, you file these type of documents, number one, they're very serious, and generally you're filing them under penalty of perjury, that you believe the facts herein are true and correct to the best of your knowledge and belief. All right, application for citation of contempt against the plaintiff, Nathan Wade, and in support thereof. We will show this honorable court as follows. All right, here we go. On January 30th, 2024, this honorable court entered a consent temporary order, hereafter called temporary order, in the above caption matter, incorporating by reference as unified consent temporary agreement, quote, temporary agreement, just a bunch of legalese here. We'll be through this in a second, which was reviewed and approved by the court. The parties agreed that the temporary agreement would not be filed with the court or disseminated to third parties unless there was an enforcement issue. So why would they do that? Well, the eyes of the world are on this particular case. Remember, they had an agreement in principle, so they just verified exactly what I was thinking. They actually were before the court, and the court signed off on their agreement that they had between them. It's just that simple. And because they don't want the world knowing what their private agreement is, this is generally how you do it. You have to file the documents with the court, but a lot of times if you want to keep it private and the court allows it, you can say, here's our agreement, and our agreement we're going to call something else, and this is what they're calling it, temporary order. And it's generally not filed with the court, but everybody knows what's in it. And unless there's a problem, like she's describing here, there's no reason for it to be disseminated to the world. It's just a way, to make a long story short, it's just a way to keep things more private. Just that simple. All right. Or disseminate to third parties unless there was an enforcement issue. Guess what? There's an enforcement issue. Consent order, temporary order attached to is Exhibit A. There we go. This is what I was talking about. Consent temporary agreement attached hereto is Exhibit B. I don't know if I believe that poll, but there is a Wall Street Journal poll that is a poll of, I believe it's the leading, or I should say the 7 contentious states, if you will, the what you call the border states, as far as it's a toss-up between the two. And clearly, President Trump is leading in all of those except one where he is tied with Joe Biden. Again, in the state of Pennsylvania, there's a little bit of back and forth as to who's actually winning there. And Zach says a POTUS key fringe dementia during the last few minutes of leaving office. Defendant has incurred attorney fees and expenses of litigation due to plaintiff's actions, which are clearly in violation of this court's January 30th, 2024 temporary order and the parties' temporary agreement, which was incorporated by reference. And as such, defendant is entitled to an award of the same pursuant to OCGA 1962 and any and all other applicable laws. Due to the worsening nature of the defendant's health, she would request that the court reduce plaintiff's response time to 5 days. Wherefore, the plaintiff respectfully requests that this honorable court. So here's exactly what she's want. This is what we call the prayer. This is what she's asking for. Number A, reduce the time for the plaintiff to respond to 5 days. Generally on these type things, you may have as much as 30 days to respond. Okay, issue a rule nisi placing this matter on the court's first available case. I want to tell you, I appreciate each and every one of you joining me. I always say, keep that mind free and never give up. And until next time, my friends, I am J.R. Dukes.